Good afternoon. Social media is sure lit up after the verdict in the Kyle Rittenhouse trial. I'm not taking a position one way or another on the verdict. A lot of people thinking it's something more to it than it is or is not, as the case may be. I just want to provide some insight and give you a couple explanations. First of all, the defense was that of self-defense. And I think the prosecution, what they were attempting to do was to show that the gun was illegal, therefore he had no reason to be carrying it, and therefore not be able to claim self-defense. I don't understand that position because the gun was not illegal. The judge threw that count out. Now, people got upset about it, but the statute in Wisconsin is similar to one in Michigan, which is generally referred to as the short barrel shotgun statute. The barrel cannot be less than 16 inches, just the barrel, or the overall length of the weapon cannot be less than 26 inches. If it is, it's illegal. They call it a short barrel shotgun, and they do that because people can generally conceal it under their coat, and that you don't want people doing it. That was the same thing they have in Wisconsin. In this case, the weapon was an AR-15. Clearly, it's over 26 inches, so it doesn't comply with the statutory prohibition against short barrel weapons. And that's why it got dismissed. I don't know why it wasn't dismissed before. Frankly, I don't even understand why the prosecution would bring that charge, knowing that that weapon does not fit within the statutory prohibition of the Wisconsin statute. Second, what they have here is what they did. Their argument was self-defense. Some of the jury instructions in Wisconsin mirror those here in Michigan. In Michigan, as in Wisconsin, one of the things the jury has to consider is that the defendant must have honestly and reasonably believed that they were in danger of being killed or seriously injured. If their belief was honest and reasonable, they could act immediately to defend themselves, even, now this is key, even if it turned out later that they were wrong about how much danger they were actually in. The jury instruction says that they are to decide whether the defendant's belief was honest and reasonable under all of the circumstances appearing to the defendant at that time. And let's just stop there. So what you have, and you can see it from the video, he was being chased. One person was, let's start with the one witness his name escapes me. And he testified in the trial. And he testified that he was a medic, but that he had a .357 handgun. And he, at one point, when running after Kyle Rittenhouse, pointed his gun at him. He pointed the pistol at him. And it was at that point that Mr. Rittenhouse fired his weapon at him and shot him he shot him in the upper arm. And, he testified to that at the trial. The prosecution called this quote victim as a witness, and he testified at the trial when asked by the defense, were you shot after you pointed your handgun at Kyle? And he said yes. I don't think there's any question that firing a weapon at somebody who's pointing a pistol at you is anything but self-defense. I don't think there's just no way you can't make the argument that somebody would not be in reasonable fear of great bodily harm or death, and that belief would be honest and reasonable. So any charges as it related to that victim had to go. They had to go. Okay, there was just no way that was going to be sustained. And again, I would think the prosecution, if they prepped their witness and had talked to this gentleman ahead of the trial, they would have known that was going to be his testimony. Well, if that's his testimony, why would you bring that charge? I don't understand it. Okay, I mean, I don't think nobody's going to say someone pointing a gun at you would not be an honest and reasonable belief to be in fear of death or great bodily harm, basically of being shot. Okay, I suspect many of you, if somebody pointed a gun at you and you had a gun, you're going to fire also. You're not going to wait and ask a bunch of questions. Second, as to, um, as we saw, Mr. Rittenhouse had been chased by people, and in being chased, at one point he was down on the ground and he was being hit with a skateboard and this and that. And again, he fired in self-defense. And again, one might think, well, why would you use deadly force to repel an attack, say with a skateboard? I mean, I get it. I understand it. But the statute or the jury instructions only say you have to have an honest and reasonable belief. And the jury has to look at it in the context of everything that was going on at that time. It is very difficult to say that, once you looked at a lot of the video, and I watched a lot of the trial, I saw these videos. And it was, I think we saw a lot of them, and it was pretty obvious at one point when he was on the ground and being attacked. But again, the jury instruction says, and I quote again, that he could act immediately to defend himself, even if it turned out later that he was wrong about how much danger he was in. Okay? And for those lawyers out there, that's Michigan Criminal Jury Instruction 7.15, use of deadly force in self-defense. And that mirrors what the Wisconsin statute, or jury instruction, provided. Now, unlike Michigan, in Wisconsin, once the self-defense evidence is put out, and actually in Michigan to a certain, it's pretty much the same as well. Once the defense raises self-defense and puts forth evidence, the burden now is on the prosecution to prove beyond a reasonable doubt that it was not self-defense. In Michigan, the statute jury instruction is Michigan Criminal Jury Instruction 7.20. So once Rittenhouse testified and he put in evidence of the self-defense claim, it then became the burden of the people to show beyond a reasonable doubt, okay, that this was not self-defense, and they failed. That they failed in that attempt to do that. It's just plain and simple. So, while people may think that it was race involved, and I'm not suggesting it was, I'm not suggesting it wasn't in terms of the jury's verdict, but I think in analyzing the facts and listening to the testimony and looking at the videos, which frankly were the best evidence of what took place were those videos, it's not unusual that the jury would come to the conclusion that they did and to acquit on all counts. And like I said, in particular, on the one where the guy said he pointed his .357 at him. There's just no way that's not self-defense. The prosecution tried to make it appear as if Rittenhouse, Kyle, was the aggressor, in which case you lose a self-defense argument if you're the aggressor. And I think that argument is lost, for example, in the Ahmaud Arbery trial that's going on in Brunswick, Georgia. Mr. Arbery was not the aggressor. Clearly, Travis McMichael and his father were the aggressors. Clearly, Travis was the aggressor. Okay? And you lose the self-defense argument if it's shown that you were the aggressor. And I think in that case, the prosecution team has done a pretty good job, I think, of showing that. Proofs there have been closed, and they'll start their closing arguments Monday in the Arbery trial. And we'll just pick it up from there. Sorry about that. We'll pick it up from there in terms of where we are. So that's a take on the Rittenhouse acquittal. Just food for thought in terms of analyzing properly what happened in terms, and for that matter, what the jury's function was. We also did learn at that time, and I was certainly one of the bigger critics of his mother for bringing him across state lines with this rifle, but apparently the gun was already in Wisconsin at a friend's house who had bought it for him, who was going to give it to him when he turned 18. So he came here and went to the friend's house and got it. Now I don't know why he's out there 17 years old carrying on like that. I mean, I would never let my son do that, but then, people make decisions and there are consequences to their act. So that's basically the take on the verdict today in Rittenhouse, and we'll see you next week as the Arbery trial begins closing and the jury goes out for deliberations.